And yep, we are live. Okay. Well, hello and welcome everyone to today's webinar as part of the EU Values Network webinar series, actually our first of 2026. My name is Emily Jones and I'm very pleased to be your host and moderator for this session. If you are new to what we're all about, the EU Values Network is a collaborative Jean Monnet initiative working with higher education institutions across the globe to create dialogue and a broader understanding of the EU's normative values. You're very welcome, in fact, greatly encouraged to follow and subscribe to our work on any of your favorite social media platforms. We have podcasts, short videos, blogs, and if you love hearing from experts directly, I imagine you do as you're here today, I recommend subscribing to our YouTube channel where we will upload this webinar recording. We have others, and we also have longer form interviews with experts there as well. So today, in this webinar, we're delighted to welcome Dr. Shelley Marshall, Dr. Fiona Haines, and Dr. Kari Macdonald, co-authors of the recent book, Global Business and Local Struggle, Reimagining Non-Judicial Remedy for Human Rights, written with Dr. Tim Connor and Dr. Annie Delaney as well. Dr. Shelley Marshall is an associate professor at RMIT University and a leading scholar in labour regulation and global supply chain governance. Her work focuses on the lived realities of workers and communities navigating regulatory systems, and she will present the core findings and arguments of the book today. Dr. Fiona Haines is a professor of criminology at the University of Melbourne, whose research has been highly influential in the study of regulation, risk, and global governance. Her work brings critical insight into how regulatory systems shape and are shaped by power and inequality. And Dr. Kari Macdonald is an associate professor at the University of Melbourne and a leading expert on transnational governance, on labour rights and global justice. Her research examines how accountability mechanisms function across borders and how they can be redesigned to protect human rights. We're also really pleased to be joined by Dr. Kari Otteburn from KU Leuven, who will serve as a discussant for today's session. Dr. Otterburn's work focuses on businesses and human rights and transnational accountability, and her reflections will help situate the book's contributions within the broader debates of the field. Together, our panelists will guide us through key questions about the future of human rights remedy, the role of non-judicial mechanisms, and the evolving landscapes of global business accountability. And if you're watching live, you have the opportunity to submit your comments, your questions, and we'll come to those towards the end of the session, but feel free at any point throughout this session to just jot those down. In the bottom of your screen, you'll see something called Q&A, and that's the place that you can put those. And well, with that, a huge thank you on behalf of the EU Values Network. I'm very happy to hand over to Dr. Shelley Marshall now for the presentation. Over to you, Shelley.
Thank you. Thank you so much for that very warm welcome. It's so exciting to be finally talking about a full published book. Is my screen showing okay and just the presentation?
Yes, you're good.
Great. Thank you so much. So, as scholars and policy makers in this network invested in global governance, we're often tempted to by a specific kind of, if not trust, then at least optimism about the capacity of institutions to deliver justice. We look at the grim reality of human rights violations in global supply chains, land grabs, forced labour, and we optimistically seek an institutional fit. And it was this optimism in part that drove our book, leading us to ask, how do we design a grievance mechanism that's accessible, transparent, and fair? And as a lawyer, in particular, certainly that's not the perspective that my co-authors come from, but as a legal scholar, it's especially tempting to operate on the assumption that if we build the perfect machine, a non-judicial mechanism or some other kind of mechanism, we can input a grievance, process it through neutral dialogue, and output justice. And certainly at the time that we began our research, there was a kind of general optimism about the capacity of non-judicial mechanisms to deliver redress. And indeed, because we started this book or started this research 15 years ago, it was a time when there was a proliferation of non-judicial mechanisms. So it felt particularly timely. And as Fiona said last night at the in-person launch that we had, boy, did kind of views about non-judicial mechanisms change over the period of our research, over the 15 years that it took for this book to actually come out. But at the time that we started doing this research, the United Nations Guiding Principles on Business and Human Rights had just been passed unanimously through the UN Human Rights Council, and part of that was the effectiveness criteria. And I'm not going to go into that too much, but most of you will be familiar with these kind of procedural characteristics: legitimacy and trust, transparency, accessibility, rights compatibility, dialogue-based continuous learning. These are the kind of the criteria that are in the United Nations guiding principles that we were led to believe, or at least are the kind of gold standard in terms of what we expect in a non-judicial mechanism to make it effective. And while I hate to spoil the ending of the book so early in this presentation, the findings of our book, based on all those years of fieldwork across agribusiness, mining, and apparel sectors in India and Indonesia, suggests this view is in fact fundamentally flawed. And again, while that seemed groundbreaking at the time that we found this, I think that the view has kind of come around to this perspective more widely. But our central finding is that if we judge these mechanisms by their ability to fix a problem through their own internal procedures, they are widespread failures. In almost every case we studied, the mechanism itself couldn't stop the violation. But what we found is if we shift our perspective, if we stop viewing regulations as fixes and start viewing them as tools for empowerment within a broader political struggle, a different picture emerges. We found that effective regulation doesn't solve the grievance in isolation. Instead, it empowers marginalized groups to fight their battles by connecting local struggles to transnational sources of leverage. So, to understand why institutional design alone is important but not sufficient, we need to look at the power dynamics on the ground. And to do that, we conducted case studies of struggles. So instead of starting with the institutions, we started with the communities and groups of workers who suffered a grievance of some type. Our selection criteria required that they be engaging with at least one non-judicial human rights mechanism. But in fact, with the kind of more empowered organizations, what we found was they were actually trying multiple mechanisms, non-judicial, judicial, making complaints, wherever they could to try to get some kind of leverage. We then followed that community as they sought justice. And in general, each community or worker group pursued, as I said, multiple fora, but at times they merely sought advice and then dismissed a particular state or non-state avenue. So I'm thinking, for example, of one of the case studies that we looked at in Indonesia, where the community thought about pursuing the court system, but believed it was so biased that they didn't even try. And other times they did try, but they were stymied by various barriers. And at other times they pursued an avenue doggedly over years, and we had the great privilege of following them while they did that. So our key finding really very early on was that procedural adherence has mixed outcomes. Across all of our case studies, we found that getting the procedures right within a non-judicial mechanism was never sufficient to ensure redress. So why? Let me take you, in the time that I have, through a few contrasting case studies. In the most depressing cases that we followed, the aggrieved community got nowhere because their power was just so low. So, in our case study of leather footwear, a leather footwear sector workers in Ambur, India, women were working in their homes stitching shoe uppers for export to some really major brands, including UK brands. And they were paid meager piece rates and were being exposed to toxic glues, and there was all kinds of environmental damage that was occurring because of that as well. And they were highly dependent on intermediaries for their daily work. Now, following a 2012 report by European NGOs regarding child labour, brands established stitching centres that successfully removed children from the supply chain, but they failed to increase women's wages, paradoxically increasing their financial hardship. And when efforts to organise this work starting in 2013 first began, they collectively chose not to lodge a formal complaint with the Ethical Trading Initiative because they feared that global brands would just cut and run from the region rather than fix the problems. And they had good reason to believe that might be the case because they'd seen that kind of withdrawal in other cases. So we pursued this case study hoping to see a non-judicial mechanism complaint, and in fact, none occurred because their power was so low. So in this context, it didn't matter if a grievance mechanism in Geneva or London was accessible on paper. The structural power imbalance was so profound that the mechanism was simply irrelevant. So if good design isn't the magic bullet that frankly I was hoping that it would be, then what is? To answer that, let's look at the Wilmar case in Indonesia, which was, I guess, one of our kind of success story cases. It illustrates exactly how a mechanism can fail to fix a problem, but can still be used to empower a community. So, in case you haven't are not familiar with the company, Wilmar is a global giant in palm oil. And in the Sambas and Jambi regions in Indonesia, indigenous and local communities face displacement and the loss of their forests and therefore their livelihoods to make way for plantations. The communities, with a great deal of assistance from NGOs, filed complaints with two mechanisms: the Complaint Advisor Ombudsman of the World Bank Group and also the Roundtable on Sustainable Palm Oil. So we had the opportunity to kind of track both of these complaint mechanisms and follow them. And if we look at this through a legalistic lens, the mechanisms really struggle. So in Jambi, despite years of mediation, Wilmar eventually sold the specific subsidiary involved, PT Asiatic Persada, to a company with no ties to the World Bank or the RSPO. And by selling the problem, they actually removed the jurisdiction and the grievance mechanism. And so the mechanism couldn't apply and it failed to bind the company in both cases, both in non-judicial mechanisms there. But the communities achieved significant partial access in other regions, such as Sambas and Riau, where they gained land sharing agreements and compensation. And there, the reason was because they still had that leverage, not because the CAO ordered it, but because the communities and their allies successfully reshaped the field. And I'm not going to go into the theory that we applied here, but really suffice to say that they use the grievance mechanisms to trigger countervailing power in three ways. They leveraged the buyer, so the communities and NGOs like Sawit didn't just talk to Wilmar, they also used the EU Renewable Energy Directive, which mandates sustainable criteria for biofuels, and they targeted Unilever, which is Wilmar's greatest buyer. And they eventually took a family from the plantation to Europe to protest at Unilever's offices. And this brought about great pressure on Wilmar, with the grievance mechanism validating the community's claim, making it impossible for Unilever to ignore. They also used financial leverage. The complaint triggered a compliance audit by the CAO. And because the International Finance Corporation had investments in Wilmar, the audit threatens Wilmar's access to finance. And then local solidarity was incredibly important here. In the village Pinang Tinggi, the community had a robust system where family leaders would meet after every negotiation session to mandate their representatives. And actually, we found this across all of our case studies where there was community cohesion. The campaigns were able to continue, but where it was absent, companies often successfully divided communities. So the lesson there is that the NJM, the non-judicial mechanism, wasn't the judge, it was the hook. It was what allowed the community to pull on chains of global finance and European regulation to kind of bring in extra leverage in the struggle that they were engaged in. Another case study that we conducted where we saw a similar dynamic, which was possibly even more dramatic, was in the Vedanta case in Odisha in India. And many of you might be familiar with this. Vedanta is a massive mining conglomerate. It grew in India, but it's listed in the UK, and it planned to dig an open pit bauxite mine in the Niyamgiri Hills. And those hills are sacred to the Dongria Khond, an indigenous community or Adivasi community who feared the destruction of their way of life, but also of their kind of spiritual life source is how they see that hill. So the community, represented by an NGO called Survival, lodged a complaint with the UK National Contact Point. Because Vedanta was listed on the London Stock Exchange, they were able to do that, and they did that because they wanted to, the UK National Contact was seen as one worth testing out. Again, though, did the UK National Contact Point fix the problem? Well, not really, because Vedanta refused to even engage in mediation. They ignored the process entirely. So, by the standards of dispute resolution, you could see it as a total failure. But happily, the story didn't end there. The activists used the National Contact Point's final statement, which ruled that Vedanta had breached human rights guidelines, as a weapon in a broader war. So they use what we call a pincer movement of local and international pressure. They conducted a reputational and financial attack. So they took it to institutional investors, and a number of key institutional investors sold their shares. They used discursive power. They framed the struggle as a David versus Goliath battle, or more relevant at the time. They invoked the movie Avatar, and in the pictures I showed you before, they kept kind of painting themselves in blue and going to shareholder meetings. But ultimately, actually, the mine was stopped by the Supreme Court of India, which ruled that the local village councils, Gram Sabhas, had the right to vote on the project. And we were so lucky that we were following this, that we actually saw as each of the villages, the relevant villages, voted on this and unanimously voted against the mine. And that resulted in the mine being stopped. It was the Supreme Court of India. It wasn't the National Contact Point ultimately that resulted in the mine stopping. So in some ways, the UK National Contact Point was peripheral, but it did provide the discursive legitimacy at the international level that fueled this shareholder revolt and bolstered the global campaign, which kind of bolstered the network. So, what did the cases show altogether? Well, quite obviously, they show that that NJMs, non-judicial mechanisms, don't deliver remedy alone. Instead, the way that we see them is amplifying political opportunities available to communities and worker groups. So, what does this mean for the EU network that's interested in values of democracy, and particularly concerned with foreign policies? Well, I think one thing it means that we kind of need to abandon the idea that we can export good institutions that will act like mini non-state courts. The lesson of our case studies in the tea sector, the apparel sector, and the mining sector is that power matters. In the cases where there was any successful outcome, and you can see from this table that a successful outcome was rare, where there was any kind of successful outcome, the non-judicial mechanism played a role in addressing power imbalances in some way. So the lesson for us is that non-judicial mechanisms really need to be designed so they're responsive to the political dynamics. In particular, the specific power dynamics in the field that they're entering, and that will be different in each case that they're involved in. So we think that non-judicial mechanisms need to harness descended power. They should be designed not just to mediate, but to actively pull in other powerful actors, buyers, investors, insurers who have material leverage. And, certainly we saw that was the case in the successful cases that we studied. And we think that they should be strengthening, not replacing the state. So, for those of you who engage with this particular body of literature, you will have seen endless papers debating whether hard or soft law is more effective. And indeed, because NGMs are often seen as alternative to the state, this is a debate that's even possible. But in the Indonesian sportswear case, for example, that we looked at, trade unions used the transnational mechanism to pressure the police and National Human Rights Commission to do their jobs. So the transnational mechanism didn't replace the state. In that case, at least, it shamed the state into action. And we often saw kind of really complex relationships between a transnational non-judicial mechanism and the state. And there's a whole chapter on that in the book that I invite you to look at. For communities or for civil society, for us, the lesson was that they should never rely on non-judicial mechanisms alone. They might use a complaint to generate data, a media hook, an investor alert that fuels a broader campaign, but it's just kind of one strategy amongst many. And this isn't new to civil society organizations because again, as we were tracking them, we saw that the more empowered ones were, trying as many different opportunities as possible. So to conclude then, the landscape of human rights redress, I mean, it's undeniably bleak. And our book, it really does document, I think we'd have to honestly say, widespread failure. But within that failure, there were seeds of optimism. There were, partial successes. And those seeds didn't grow out of technocratic fixes or rules. They grow when we understand that these are political struggles. So, for example, the Wilmar communities didn't win because the CAO was a perfect institution. They won because they connected their local struggle to European regulations and to global finance. And likewise, the Dongria Con didn't save their sacred hills because the UK National Contact Point ordered Vedanta to stop. I mean, as I said, Vedanta completely ignored the whole process. They saved them because they used the national contact point to make Vedanta toxic to global investors. So, for this network, I think the key takeaways are that promoting the values of this network isn't about reforming institutions in accordance with a static set of rules. It's about building institutions that empower marginalized groups to weave together webs of pressure. And that's legal, financial, political, that are strong enough to hold power to account. Thank you.
Thank you. Thank you so much, Shelley. A really lovely overview of the book of, well, the failures and the seeds of optimism, as you noted there at the end. Huge congratulations to you and your co-authors on
Thank
15
you.
years worth of research.
Oh, well, not 15
It's
years of
thrilling.
research, but 15 years
Uh,
to bring it to fruition
oh,
anyway.
goodness. Huge
Yes, thanks.
congratulations.
Thank
Well,
you.
for those in the audience today, if you have any questions or comments, do send those in the Q&A window. We'll come to those in a little bit. We will now turn to our expert discussant with us today, Dr. Kari Otteburn, for her thoughts and reflections on the book. Over to you, Kari.
Thank you, Emily. And thank you so much for inviting me to participate in this discussion. I was really excited when I first saw this book come out because I've been working on this exact topic since about 2018. So definitely not as long as they have been working on it, but for several years now. And when this book came out, I was just a tiny bit apprehensive because a lot of the way I've justified my academic contribution in past articles or in the past has been sort of as responding to this almost near absence of empirical or ex ante research on non-judicial mechanisms, with the exception of actually some articles of the authors here. But now I guess I can't really do that anymore because now there's this massive empirical work. So I'm going to have to work harder to justify my academic contributions going forward. I'm sure I'll be better for it, but thank you for that. But just kidding aside, I really want to express that I'm incredibly impressed by this book. It's truly an enormous injection of empirical work into the study of non-judicial mechanisms, as I mentioned. The authors took really extreme care to look at the historical and the political and the cultural and the economic and legal context that shape each case. And they really didn't leave any stones unturned. They talked to local labor inspectorates. They talked to villagers and village heads, and they talked to trade union representatives and workers. On tea plantations, they talked to NGOs. They talked to pretty much everyone, and it's really incredible the amount of insights that they were able to turn up, and that they committed so much time to uncovering. And it really gives this look at that you didn't really see before about what the impacts of non-judicial mechanisms really look like, not only in practice, but actually in these local contexts where the communities and the rights holders actually live and work. And this relates to another major contribution of this work, whereas the business and human rights scholarship, as Shelley mentioned, the work in business and human rights is often looking at these debates between hard law and soft law. And in general, a majority of business and human rights scholarship falls within the legal discipline, takes a legal approach. But this book really differs in bringing in a lot of different social science disciplines from well, starting with political science and regulatory governance, but also including political economy and sociology, anthropology, and I think even more. And this approach has been extremely fruitful. First, the research does confirm some findings of previous scholarship. Of course, it also negates some and also qualifies things in a way. But the one contribution, I think, of this work is that it empirically confirms the inadequacy of the effectiveness criteria of the United Nations guiding principles. Some scholars have argued for this, but this is more theoretical, and you've been able to empirically demonstrate the inability of non-judicial mechanisms to offset these power imbalances between multinational corporations and rights holders. This has been assumed to some extent, but with limited empirical evidence until now in the business and human rights context. So I think that is a huge, important contribution of this work. And maybe more important, your incredibly thorough empirical approach has produced many novel insights, as I mentioned. For one, was particularly struck by your overview of how host states interact with transnational non-judicial mechanisms. I hadn't really given much thought to these interactions in the past, but knowing that transnational mechanisms are sometimes viewed as a threat by host states, and there's been attempts by state actors or even at the local level to undermine non-judicial mechanisms, activities, and influence in certain contexts. This is an insight that you can't get from official reports, especially those from the non-judicial mechanisms themselves. Non-judicial mechanisms are usually very wary of ruffling feathers, especially from government actors for reasons of diplomacy or pragmatism, or they feel like they're overstepping their mandate. So this is not an insight that you can get from these official statements about the cases. And I know this because I've analyzed like more than 500 of these official statements, and I have not seen a single instance where a non-judicial mechanism references any kind of actions taken by a host state to obstruct their work, their functioning in grievance mechanism. So reading these case studies was like an aha moment for me, because I had not come across this before, and this is not an insight that you can get from the official statement. So this really has to come from the ground. For me, it was kind of like when you're, as an analogy, when you're watching a movie and someone's narrating a story from something that happened in the past, and then the scene cuts to actually like show the viewers that what's going on, so you actually see the story unfolding. It felt kind of like that. It was really allowing you to see these power dynamics and these political struggles and these even interpersonal tensions as they actually play out in practice and ultimately shape, as the authors call it, these fields of struggle in which the non-judicial mechanisms must operate. That was a huge insight, and I think a really major contribution of the book. And I think another crucial contribution of the book is that seeing these non-judicial mechanisms as just one actor within these greater fields of struggle, the actual impact of mechanisms' institutional design and capacity is relatively minor compared to rights holders' capacity for mobilization or seeking out powerful allies and shaping and controlling narratives, and then exploiting various strategic opportunities presented by a business's public commitment to human rights, or its business partners' concerns of reputational risk, or this international clout of the decision by a non-judicial mechanism, like how they can utilize the actual outputs of a non-judicial mechanism, which might not be remedy themselves, but they're some kind of output that can be exploited. So as such, the book does not only make an empirical contribution, but also makes a big theoretical contribution to the business and human rights scholarship and to regulatory governance literature, especially in their final proposals for how non-judicial mechanisms can actually be optimized for the pursuit of remedy outcomes in a more realistic and empirically grounded way. So congratulations on this really amazing work. I was really excited by it and impressed by it, and had a lot of aha moments while I was reading it. And it was the first book I've read so far this year, so now the rest of the year has a lot to live up to. So thank you for that. And now I'll move on to a few questions. And feel free in responding to ignore parts if you don't feel like they're that relevant. But I just have three main questions that I will start with, and then we can open up for the audience as you like. But you emphasize the capacity of workers and communities to organize and establish networks and so on. But in your cases, when I was reading the book, I noticed that you repeatedly bring up another factor, and namely that the case or situation draws the attention of an experienced civil society organization or NGO. And this NGO contributes their experience, time, and resources. And most ordinary people do not have experience with challenging a multinational enterprise. I personally don't. I'm assuming most people don't, either in a judicial forum like a court or a non-judicial forum. In courts, both parties typically have access to some sort of legal counsel to correct for this lack of experience. And in non-judicial mechanisms, it appears that NGOs play this role of like lawyers, and they step in to provide this expertise to formulate arguments, identify evidence, and so on. But the NGOs that step into this role are choosing cases strategically because they are mostly concerned with the systemic effects of that case, of amplifying that case. They're concerned with the bigger cause and the broader outcomes of the case. Of course, they also hope for redress for the rights holders, but I think their focus is always going to be on the more systemic issues. And so I was wondering if you had insights into this role of the NGO, not only in providing support, but also in this selection process, in choosing which cases receive the attention and support, and what that could mean for remedy outcomes. And you had detailed several necessary conditions for sort of improving the remedy outcomes through the non-judicial mechanisms, or in these fields of struggle in hooking in non-judicial mechanisms. But I was wondering if you see NGO collaboration as another necessary condition. Do they need to first gain the attention of these NGOs and harness this experience, especially a transnational or international NGO that has experience going after multinational enterprises? Is this something that they must do as part of their steps, building out their capacity or network? A second question concerns methodology and the application of your findings. You've studied to a very great detail 10 cases, but these cases are in 2 countries. And as you note in the book, these countries share some attributes, including their status as middle income countries, their history of democratic governance, even if it's a bit spotty sometimes, colonial histories, and also this economic reform period taking place in the 80s or 90s, from closed economies to integrating with international markets. So, and moreover, each of your cases involves groups of rights holders and mobilized different actors at a variety of levels in a broader struggle. But I was thinking back to some of the cases I've worked with in the past, and I know that some cases handled by non-judicial mechanisms are much smaller, and they might even concern a single affected individual, although usually often supported by at least one NGO. And then non-judicial mechanisms also handle grievances concerning abuses that occurred in states with vastly different economic levels, political systems, cultures, and histories than India and Indonesia. So I was wondering to what extent you think that your findings extrapolate to the broader population of non-judicial mechanisms, and do you see any limits to generalizing these findings to struggles for remedy for human rights abuses occurring in other states or in other industries or political contexts, or even just grievances lodged by different types of claimants or even smaller groups of claimants? And which of your findings do you think are going to be the most universal? And then my third question is now bringing in a bit some of my own research, because I take a really different approach. It's also an empirical approach, but I've actually come to several similar conclusions to you in your book, in my work, and we overlap in a bunch of different ways. One, we overlap that we both come to the same conclusion that non-judicial mechanisms can make an important contribution within a broader remedy architecture, but cannot be understood on their own as reliable pathways to remedy for most human rights abuses, and not even when they meet the UNGP criteria for effectiveness or even some other important measures of effectiveness identified in the literature. In other words, their institutional design cannot guarantee that they're going to function as reliable pathways to remedy. And second, that the problem-solving approach is less likely to lead to benefits to claimants. I think we both reached that same conclusion, that the accountability approach works better. It's easier to leverage a final decision and judgment by one of these non-judicial mechanisms in a public way and towards bigger aims. And then we also come to the same conclusion that non-judicial mechanisms can make the greatest contributions when these findings and decisions can be utilized by claimants and their representatives as leverage or mobilized by this broader campaign. So this is where we really overlap. But one area where we sort of differ is that my research I've shown that the severity of the human rights abuse itself also makes a big difference in whether non-judicial mechanisms are effective in facilitating effective remedy outcomes. I have a database of multiple cases, and I don't have this on the ground perspective, which your book provides, which is just amazing. But from official statements and other types of ex-ante research, I compare 81 cases and find that non-judicial mechanisms are actually pretty good at facilitating minor forms of remedy for less severe abuses of human rights. Obviously, it's a bit difficult to rate severity of human rights, but I look at it in terms of reversibility and also scope. So if you have a smaller scope and you have a high possibility of reversibility, that remedy outcomes are quite a bit better and actually compare in terms of, I guess, percentage of success rates to courts. They're maybe even better than courts at minor remedies for sort of so-called minor abuses. And I'm wondering if you noticed any differences in the role non-judicial mechanisms are capable of playing for different types of abuses. I think the different contexts that you were looking at all varied to a degree, and I'm wondering if you noticed any differences in how the severity or the nature or the type of the abuse might change the potential position of non-judicial mechanisms in that field of struggle. And I think I'll start with those questions, and maybe I can jump in with another one in the Q&A if there's time. But I want to make sure there's time for the audience. So
What
back up to you.
great questions. And thank you for sharing some of your own findings as well. That's really great. Fiona, do you want to answer the first question since you wrote our section on civil society? The question about the role of NGOs, is NGO collaboration a necessary condition?
Yeah, look, I mean, the simple answer is yes. The longer answer is that there has to be a level of communication between the communities on the ground or the workers, the local and the international. There has to be a consistency in aim. And I think, and even where there's that consistency in aim, in the T case that Kate's most familiar with, the actual resources it takes on the ground to get, when the case is accepted by, in this case, the NCP or the CAO, the amount of effort that goes into providing the necessary material to the NGOs and civil society and allies means that it's economic speed. There's an opportunity cost there, right? So one of the things we say is because it is onerous, then you need to have a really, the communities need to be able to think through whether this is going to be a good part of a bigger plan or not, because as you rightly point out, and we found that the immediate payoff is quite limited. One thing I would say is that in certain cases in Weda Bay that Shelley's very familiar with, is that actually there was a disconnect. The local community, simply because they didn't think systemic change was possible, they wanted the problem solving. They just wanted better compensation, right? They kind of given up on the big aim. And I was in a workshop in Jakarta, and a local community rep was there, and he threw up his hands and he said, "I'm sick of NGOs, no NGOs, no NGOs." And one of their most supportive NGOs was sitting right next to them, Aman, and he was just sort of sitting there and copying this real anger and frustration that they were not being listened to. So I would be very, very careful of the finding that problem solving is not what local people want. I would say, but it's complicated, which is the typical answer. It's complicated. So what doesn't work, and again with Weda Bay, is where an international NGO makes a complaint to an NJM that actually is not what the community were asking for at all. There was concern for environment as opposed to livelihood, human rights, compensation. And there was this disconnect. In a sense, the international NGO felt that this was a good case for them, for their campaign, not for the local campaign. Anyway, I'll leave it there. So there's other people can please jump in, both of you.
Did you want to say something about the second question? And I was thinking it's so relevant to the work that we've been doing on Cambodia as well.
The second question, yeah.
Yeah.
Yeah, absolutely. Yeah, I mean, I think if we're talking about the general findings, then some of the general findings that we have would certainly translate. I mean, perhaps most obviously the ones that highlight the contextual nature of the power relations in the field of struggle and the need for the design of non-judicial mechanisms to be responsive to the different sources of power that are there in the field, and to be helping to, rebalance those power relations in the local context, while recognising that the state, businesses, civil society organisation can all work for or against the human rights of communities depending on the context. I mean, the state, as many of the cases that we looked at showed, sometimes elements of agencies within the state can be great supporters and, can help the communities. In many cases, they're a big part of the problem. Same with business. Of course, we think of them often in human business and human rights cases as being the problem, but then often there are businesses, further up the supply chain or whatever, and harnessing their power in support of the communities is a decisive factor. And as we've just been discussing, the same can also be true of civil society. In most of the cases that we looked at, they were assisting, but, the tensions that have been highlighted by the discussion we just had show how context-specific that can be, and the need for care around that. So yeah, that need for the contextual responsiveness absolutely is true. And I think that, across different contexts, and the general findings also about the limits of an institutional, sort of a proceduralist institutional design perspective that flow from that, I think also travel and are robust across contexts. But of course, the flip side of that is that the particular clusters of enabling and constraining factors, that's what's really going to vary across the contexts. So we can't just list out, it just depends on having a civil society ally, or it just depends on what the state does, or it just, it depends on some certain feature of the supply chain. We can't do that. And that will be different in all sorts of ways across the varied contexts that you've mentioned. But in some ways, that's the whole point, I think, is the ability. And that's why the ability of NJMs to be resourced and to be able to hire the right staff who have the local political knowledge and have legitimacy in the local political environment, as well as having access to the sources of power transnationally, companies, investors, and so on. That's precisely why those design features are so critical, and not just the design features that are emphasised in the guiding principles. Does that address your question?
Yes, I think so. Thank you.
Yeah. Okay.
Fiona and Kate, do either of you have anything to say about Kari's really interesting finding about NJMs being better at facilitating remedy and less severe human rights complaints?
Oh, look, I would love to have a more detailed conversation about this. Actually, we must do that, Kari, another time, and hear some more about your framework, scope and reversibility. I mean, because we could really unpack what we mean by severity first of all, right? So I was just trying to think, okay, of our cases, which ones were severe, which ones were individual or collective. I mean, there were some cases where people were killed, on plantations where workers died. There were situations where people, their houses were bulldozed, they lost their livelihoods. Criminalisation occurred then when, people were protesting, or et cetera, et cetera. So certainly we did traverse, what I think any of us would think of as severe human rights abuses. And I think that would meet your criterion of non-reversibility, death, or, so some of these things certainly would meet that criterion. Scope is interesting though. And we could talk more about how scope is conceptualized, because when we start to think about, so I would love to hear more about, if we're talking about things being large in scope, I would start to ask myself, okay, that suggests to me that there may be a correlation between the kinds of cases where the large scale, and that could be they're persistent through time, they're applying to a lot of people, it could be that they're institutionalized in certain ways. And all of these things suggest to me this is the kind of scenario where you would expect to see a correlation with the kinds of projects or economic sectors in which really powerful state and business actors have a large stake. And so you would expect these to be the kinds of scenarios, severe human rights abuses understood in that sense, in terms of how I'm imagining scope, would be likely to be precisely the kinds of cases where we did see failure. And the reason that we saw failure was because of the power imbalances and because of the coalitions of state and private sector actors who were really committed to a project, because it was a strategic sector, because they had personal interests in it, et cetera, et cetera. So that would be my, without knowing anything more about the cases you're looking at or precisely how you're conceptualizing scope, that would be my first hunch that yes, our findings would, in a sense, be consistent with that, and that may be the reason. But that wouldn't necessarily, there could be other types of severe human rights abuses where the political economy was different, or where the nature of the severity was different, where that wouldn't necessarily apply. That's just a sort of a hypothesis to put out there.
Yeah,
if
thank
anyone
you.
else wants to jump in on that.
Yeah, that's fantastic.
Fiona and Shelley, I don't know if you wanted to jump in on any. Also, was someone else going to jump in? Have we got questions?
Yeah, leave it to Emily to guide us now.
Yeah, sure. Well, first of all, thank you, Kari, for your insights and also the responses there to
Thank
those
you.
brilliant questions. Yeah. So we do have a question from Catherine Macdonald. If you prefer to read it, by the way, as well, I'll read it out loud, but if you prefer, it's in the Q&A box there at the bottom. So Catherine says, thank you to you all. I'm really looking forward to reading the book. Your earlier work has been really influential for me in my PhD research and gave conceptual language for experiences I had in my time working as a legal advocate using NJMs, and framed so many of the issues in a much more robust way, especially around the dynamic nature of power. The findings about NJMs being ill-equipped to be effective on their own and the need for more power-sensitive approaches aligns with my findings. I have two questions. Catherine has two questions. The first is whether in your cases you came across corporate strategies of trying to obstruct or prohibit that complementary advocacy that helps to provide power on the rights holders' side. Rights holder side, just want to get that right. The other question is about the challenges in improving NJMs in the context of what Fiona Haines and co-authors have previously described as contestational grievances, such as those that reject a development project. Maybe the answer is in the first question, that the NJM is not the solution itself. Yeah, as I say, if you need to read that as well, please do. It's in the Q&A. And thank you, Catherine.
Yeah.
Great questions.
Thank you. That's a great question. Yeah. Fiona, did you want to have a go at them? And we could probably all jump in on that. Did you want to jump in first?
Just very quickly, yes, to company obstruction. I mean, the Wilmar case with the one arm of Wilmar selling, I mean, what NJMs do is they kind of change jurisdiction or change the boundaries of the field. And so if a company wants to escape, it'll just, pay back the money or do something, So there's lots of creative ways they obstruct. The contestational grievance, just very quickly on that, POSCO was the one of the cases in point where they were very clear that they had an alternative path of development, and therefore they were very wary of not national contact points because they saw them in part as part of the neoliberal project. But there's a real dilemma. So in the POSCO case, the communities were successful in rejecting POSCO, and POSCO left India. And then the Indian government and Odisha government really wanted the project to go ahead, and they brought in the Indian multinational, steel multinational, JSW Steel, which meant that no international NGO and judicial mechanism had any role. So there's just, there's just these kind of combination of issues, and I'll leave it there to give others a chance to speak.
Yeah, I mean, maybe if I just quickly jump in just to say, yeah, definitely. And I'd say that the corporate strategies for trying to obstruct that complementary advocacy that you mentioned can range very widely, ranging from just good old-fashioned violent civil society repression, hiring gangs to go and beat people up, paying the police to come and arrest people, or, through other networks of links, getting people arrested. So I mean, I think that would be an example of company strategies trying to repress the forms of advocacy that build power. So definitely there are cases of that, ranging through to much more technocratic strategies, and I think importantly for our argument, also proceduralist strategies, actually taking a commitment to, procedural principles of consistency and so on, to actually try and stop that happening. And actually one of the early points of contention that played out around the Wilmar case, when some of the NGOs were bringing cases to the compliance advisor ombudsman, was precisely about this, about whether or not, while the mediation was going on, they had to hold certain information confidential. It was being argued by the companies that it was a breach of good faith if they were saying negative things about the company publicly and running a campaign at the same time that they were at the negotiating table. And, in a court process, often these sorts of principles would apply, that you're not allowed to go screaming stuff publicly when there's some kind of mediation going on. And so companies would try to harness procedural protections, those sorts of features of so-called good design, as a way of precisely clamping down on the organising power, which, as we see through our cases, it actually needs to be there in order for the negotiation to yield an outcome. And so, again, that sort of feeds into the design. Well, actually, if you want to design it, that's not the right kind of design. It's a different kind of design where you let them have the campaigns at the same time as you protect other procedural issues. So, yeah, I think it's a great question and many aspects to it.
And I don't know.
Did anyone else want to jump in on that? Yeah, sorry.
No?
Go.
Shelley's shaking her head. I just wanted to give Kari the opportunity. You said you had another question. If you wanted, we have maybe 2 more minutes if you wanted to ask your question too.
Sure. Yeah, I can. I'm also fine with maybe asking it via email if we're at the time limit, but as you wish. So your conclusions seem to suggest that non-judicial mechanisms sort of need to be like restyled or rebranded in a way, and understood less as pathways to remedy or as remedy mechanisms, but more as a tool for helping a quest for remedy. And your cases demonstrate how limited the impacts of non-judicial mechanisms on local contexts and for how limited the impacts of non-judicial mechanisms are on local contexts, but also for systemic change. And then you also bring in this idea of reprisals against claimants, which you see due to the involvement of non-judicial mechanisms. And these cases involve these plethora of local actors, and so the involvement of non-judicial mechanisms can start to feel like overreach when it gets more involved at the local level, and it seems like that's what this pushback is sort of resulting from. But at the same time, you argue that a problem with non-judicial mechanisms is their capabilities that are skewed towards transnational scales, and that they should actually rebalance to invest and build out more relationships and capacity at the local level. And I was just wondering what you think about this tension. I was wondering if you could weigh in on this tension. Do you think which way do you think non-judicial mechanisms should best contribute to remedy outcomes? Do you think that they are maybe too involved at the local level and because they're causing these reprisals, or do you think that it's possible to garner enough resources and local level capacity that they can actually make a meaningful impact at the local level and sort of negate some of those opportunity costs, as you mentioned?
Do you want me to say something on that? Oh, good.
Yeah, just very quickly on that. I think it's important to say that their connections on the mechanisms, connections on the ground can be a protection against repression. So in the Freedom of Association Protocol, the very fact that they had a local presence amongst these factories meant that they had some capacity to be a resource when the police came around or repression happened. So I think, but it requires NJMs to exhibit a level of diplomacy. And I think at this point, I should let Kate and particularly Shelley speak on that sort of diplomatic challenge, because it is, Yeah.
I mean, I think it speaks to, well, it actually relates to the point I think you made, Kari, in your comments, which was fascinating about pushback from the local, state actors in some cases, and resistance and so on, and the fact that that doesn't get documented. I mean, it speaks to this deeper tension in the nature of a non-judicial mechanism, that they're deriving their legitimacy in part from the idea that they are adhering to sort of judicial norms and procedures and so on. In part, that's how they're getting their legitimacy, because they're saying, oh, no, we're not meddling in your politics, where it's that they're presenting themselves more through a judicial frame of legitimacy, which is very different to a political frame of legitimacy, which they're not claiming. And so and here's the big paradox, really what we're arguing is they're only effective if they're actually able to intervene as political actors. Right. And so what that means is there is precisely this deep tension that they have to confront in actually operating as political actors without being able to directly claim legitimacy that way. They always have to subordinate, themselves to the state and its political authority where they come in tension or where that's directly challenged. And so the process of NJM's building legitimacy then is crucial in enabling them to play a political role without overstepping and losing their legitimacy and therefore losing the capacity to do all the things that we want them to do, protecting from repression, rebalancing power, all those things. So I think you're putting your finger on something really, really crucial here. And again, the sort of lazy way to sum that up, but I think also crucial is that it really then just has to be navigated in the local context. So it comes back to it will be different in different contexts, and it's crucial that those who are designing and staffing these institutions have the ability to play that game and have the ability to build legitimacy in playing that game in a particular context.
Which goes to your conclusions of the necessity for responsive design that you reach in the book. Yes. Yeah, no, it's really interesting. Thank you. That's really interesting.
Yes, thank you all. Great questions and answers. And well, I hope you're all able to stay connected and unpack it a bit further over email or future meetings as well.
Yeah, we will. Yeah.
And well, with everyone with us today, this brings us to time. Thank you so much. A huge thank you to the speakers that made it possible today. If anybody would like to rewatch or share this session, please do. It'll be on our website and YouTube in the coming days, along with a link to the book. So yeah, check it out. And once again, a huge thank you to you all on behalf of the EU Values Network. Thanks.
Thank you so much. Thank you, Kari.
Thanks, Emily. Thanks, Kari.
Thank you. Bye.
Bye. Bye. Thank you.